Hi, everybody. Today, I am super excited to bring Patrick Macqueen. Y'all have seen Patrick interviewed with me over the previous years. And today, we're going to talk about a huge change with regard to Arizona's new law, Patrick, on short-term rentals and HOAs. So tell me the scoop, because there is stuff flying all over right now. Get us the debrief. What do we need to know?
Yeah, it was a pretty big decision. It's something that, we as real estate attorneys had been hoping for. We just wanted a decision to know one way or the other what was really going to happen. And so now the Arizona Supreme Court has ruled in a case called the Kalway case. And I'm not saying Callaway in terms of the golf club manufacturer like Calloway. It's Callaway as in Kalway. And this wasn't even a case involving short-term rentals. It was a case purely involving HOAs, but we think it's going to have a huge effect on short-term rentals, which has been a huge issue, in a huge industry in here in Arizona for the last while. And so if you remember, I'll give us a little bit of background. If you remember in 2016, Governor Ducey passed a law that basically said, listen, cities, towns, municipalities, you can't do much in terms of regulating short-term rentals. You can only pass ordinances that affect health and safety of your residents. And if they happen to apply to short-term rentals, okay, that's fine. But you otherwise can't prohibit or restrict short-term rentals. And so what happened was a lot of HOAs reacted, and the HOAs came out and said, well, we're going to ban short-term rentals altogether, or you can only do a couple each month or a couple each year, or you're going to have all these crazy registration requirements. And what they were doing was they would amend their CC&Rs to prohibit short-term rentals. Well, now we have this case called the Callaway case, which basically came out with a new rule involving amendments to HOAs. And again, remember, this case didn't even involve short-term rentals, but it's going to have a huge effect on it. And so under this new guidance that we finally have from the Supreme Court of Arizona, so it is now law, okay? Under Callaway, an HOA amendment to restrict anything, including short-term rentals, is invalid unless you have a 100% vote of all the members, or a lesser vote is permitted, is okay if the CC&Rs provide for a lesser vote amount, if and only if that specific issue was already addressed in the original declaration.
Wow. So Patrick, give me an example, because you're right. This is significant because it's not just short-term rentals. This is just HOA changing their mind on what they're going to enforce. So kind of walk me through, what does it really look like?
Yeah, so let's say that you get notice that your CC&Rs to your HOA, the CC&Rs are conditions, covenants, and restrictions that most HOAs have. Let's say that the HOA comes out and says, we want to amend them to require that you, Kelly, and all of your neighbors put in white picket fences in front of all of your yards. And you say, wait a minute, I don't want to do that. That kind of pulls away from the natural look of the front yard or whatever it is. In that particular situation, what we would have to actually do is look at your original set of CC&Rs. If there was something in the document requiring fencing, well, then guess what? The amendment is probably valid. But if there was nothing addressing fencing at all, and now they come out with this new amendment that says everybody has to have white picket fencing in the yards, it's invalid. And so if you think about it in the short-term rental context, let's say that the CC&Rs, or there's a vote to disallow the short-term rentals, and then a new amendment comes out. So the new amendment says you can only do long-term rentals, anything over 30 days, and we've come out with this new amendment. But there was nothing in the original set of CC&Rs that said anything about rentals or anything about short-term rentals. Guess what? Invalid. And so what we're seeing right now is a great effort now by homeowners who wanted to do short-term rentals, who didn't want to put in a fence, who wanted to park their RVs, whatever it may be, saying, oh, all of these amendments that were passed in prior years are now invalid because there was nothing. You pulled the wool over my face. You pulled a fast one on us. You never said I couldn't do this in the first place. The documents never said I couldn't do this in the first place. And now you're restricting it. Nope, that doesn't work for me. And so now, and by the way, this case is retroactive in nature. And the court said that. So basically, we can look at all sorts of amendments going back for years to determine whether HOAs actually could have amended those CC&Rs in the first place. So it's quite a fascinating thing that we're going to have to deal with. It addresses now the grandfathering argument that a lot of short-term rental owners had. They would say, well, look, I've been doing this successfully since 2014. There was never anything in the original document restricting me, and now you're restricting me. I should be grandfathered in. And some HOAs would say, sorry, you're not grandfathered in because HOA rules can change at any time. And some courts agreed with that. Well, other courts said, no, it's not fair to not grandfather somebody in. So we had this big clash, but now we have an answer. Now we know, we look at the original document, the original set of CC&Rs, or every single person in that community has to agree to be bound, which you're never going to get 100% vote. So that's a mouthful. That's a lot. There's going to be a lot to this one. But that's a huge update in the short-term rental industry. It's a huge update in frankly, HOA law.
And this is statewide. This isn't specific to a particular city.
Statewide. It's going to affect everybody here in Arizona.
Oh my goodness. Here we go. You're going to be very busy, Patrick.
I know. I know. So yeah, I mean, we were busy in the industry, already, but this is going to be an interesting. We've received a lot of questions on, I get these quick little emails from people. Hey, do you think this is enforceable? Can I go after my HOA now? And the answer is, I don't know. We'll have to take a look at the original set of CC&Rs, see about the vote, that sort of stuff. The unfortunate part is that there was no real guidance provided by the Arizona Supreme Court in telling us how we go about, making these invalid. I don't know how you just make a recorded document invalid like that. Do you have to give notice to the HOA? Do we have to take it to court? Hopefully it's an easy process. Hopefully the HOAs will just say, oh, we goofed up on this one, but I don't think that's going to happen. So that is going to create some more work.
So if somebody's watching this and they have had an issue, let's say with their HOA, the place they want to start is going back to the actual CC&Rs that they were given when the house was built or when they purchased the property. Is that correct?
Yeah, exactly. That's right. That, it may be from 1970, it may be from 1990. And that's where we're going to go back to and see if there's anything in that document that puts us on notice. Now that a change may happen. Now, relative
to what the topic is, right? Exactly. So the white picket fence or the short-term rental or whatever.
Or the parking or the RV park, whatever it is, that's exactly right. So it's very topic specific. Okay. And so you're going to be narrowing in. And so this is really helpful. I think this is actually a helpful case. I mean, some people, 50% of the people just aren't going to like it, right? Because it's going to allow more short-term rentals in HOAs because it's going to invalidate some of those prior amendments. It's going to eliminate the ability to amend in many cases. But what it does is it does give us a little bit more certainty. It does help real estate agents guide their clients into certain neighborhoods. They can tell their clients now, oh, this is the new rule. You may not have to worry about buying in an HOA if you want to do a short-term rental in the future, because I know that there's a lot of people who were hesitant to buy in HOAs if short-term rental was their game plan. And so they avoided that. Well, now we at least have some guidance. So we can look at that original document. Agents should advise their clients to look at that original document and see what it says. That's really the operative issue and the operative thing to look at.
I think that's so interesting. And it will really be interesting, the impact on the classification of properties that we see from a lending standpoint, because we actually have seen a tick down on second home purchases, and we've seen actually investment properties tick up. And I wonder if that has anything to do with just what people have been experiencing through wanting to do maybe a short-term rental. Maybe the HOA doesn't allow for that specifically, but it would allow for a long-term rental. So maybe that was part of just the difference in how people were classifying these properties.
Well, that's an interesting observation for sure. And I've been curious as to how this, how short-term rentals in general, but how short-term rentals in perhaps this case may affect your industry. I mean, at the very basic level, do you even know, or do borrowers even have to tell you, hey, I'm thinking about doing a short-term rental with this property, or do they just say, oh, it's an investment property? I mean, does that go into some of the underwriting?
It's a great question. So here's how it works. The deed of trust, that is the security instrument that actually gets recorded once somebody purchases a property, if they're using a home loan, that's going to dictate what they can do with the house. So if it's a primary residence, if that was the classification that the loan was underwritten to, it will indicate that it's your intent to occupy this property within 60 days of close of escrow for 12 months. Boom, that's primary residence. If you're purchasing a second home or a vacation home, this is where this conversation often comes into play, because now it's one of those situations where, hey, I really want a vacation in sunny Arizona, but I don't want to be there in August, right? Or whatever the scenario is. And my intent is when I'm not vacationing there, I want to use it as a short-term rental. So what's interesting about the deed of trust for a standard conforming Freddie Mac, Fannie Mae type of loan is it does allow for vacation second home property classifications to do short-term rentals. They just can't put a long-term tenant, they can't release control over that property for 12 months. And that's what they agree to in the deed of trust. Whereas on an investment property, they can do whatever they want with it. So in the investment property, they can do short-term rentals, they can do long-term rentals. They're not prohibited by that 12-month agreement. So that's kind of the difference.
Okay.
And it used to be that there was a really big difference between short-term rental interest rates and investment property interest rates, but that changed this year with the conventional conforming guidelines issuing loan level pricing adjustments now. So now what that means is that the interest rates are more in line with each other between the second home property classification as well as the investment property. The only real benefit to the two is that you can still do a lower down payment on a second home than you could effectively on an investment property.
That's fascinating, because I didn't know if, okay, hey, I'm going to do this as a short-term rental only, or I'm going to do this as a long-term rental only. If I really want to tip my hand and tell you exactly what I'm doing, but it sounds like it almost doesn't matter as long as I'm kind of disclosing it's an investment or it's a second home. It's not my primary residence.
Right. And we're always coaching people. Like we want them to tell us a story so we can give them the best guidance. What we don't want to do is kind of have these hidden, secret language, like you're not telling or whatever. Like that doesn't serve anybody any good, because then people like you have to get involved, and we don't want attorneys involved downstream, right? Like just tell us what you want to do and we will guide you to the best loan program and product that serves what your goal is. And, being deceptive is never a good thing, because you know how these things work. At some point, something downstream could happen. And then if it goes back and that note is called due and payable because there was found to be, some type of premeditated lack of intent or different intent or things like that. We just don't want to get into that, right? So I'm of the opinion, just tell me the truth, tell me the scoop, and I will help create a financing strategy that helps you meet those goals.
Yeah, no, I love it, because, people often ask me how to coach them in applying for a mortgage loan. I'm like, there's no way I'm going to coach you. You just tell the truth. And it's really not going to make that much of a difference in rate. But guess what? You don't want somebody knocking on your door, at midnight asking you questions because you did something incorrect or you misrepresented yourself. I mean, I remember dealing with those cases from 2007, 2008, 2009, and it was like, you said what to who? I was like, no, just tell the truth. That's all you have to do.
Right. And people actually think that, oh, nobody will ever check. But I mean, I've been lending a day or two, right? So if we think back to that kind of 2008 to 2010 period, we literally had people that purchased a home as a second home. And then once that loan was transferred, either sold to Fannie or Freddie or transferred to another investor, I mean, there was actually audits that were being done. So there were door knockers that were hired by these investors that would go out, knock on the door, ask if they were the person that signed the deed of trust to just double check. So, that isn't happening anymore, but it doesn't mean it couldn't happen in the future. So the point is just tell the truth. And then, if you're buying a property as investment property, then do it that way. I mean, now, again, things change too. And this is the other thing that's important. If it's your intent today, let's say you're being relocated here and you're going to occupy that property as your primary residence. Great, call it a primary residence. Maybe you're here for 6 months and something changes and you lose your job or you have to transfer to another state and you want to retain that property as an investment property. That's fine, right? Because it wasn't a premeditated kind of intentional deception. It was life happening. And you can document that as a borrower. You can show your transfer orders or whatever it is. And that's a whole different conversation. I get that question asked all the time. Like, well, what if something happens? And remember, you're agreeing to 12 months, right? So after 12 months, then you can change without really having, much of a kind of oversight. It's when you say, I'm going to occupy this property as my primary residence, and then it goes on the market for, a lease through MLS the day after you close on it as a primary residence. Like that could be considered premeditated fraud.
Sure. No, I appreciate that explanation, because I think that a lot of people get worried that situations change. What if I have to move? The only option I have is to rent this at this time or whatever it is. So that's a great clarification. I do have one other question for you. And it's sort of the elephant in the room with rates that have gone up. And my question is, can borrowers still make short-term rentals profitable? Can they still make money on these with the uptick in the rates? I mean, I think the answer is yes, but I'd be much more curious. The better answer comes from you.
Well, the answer really is a two-part answer. One, remember that rental rates have increased also, right? So we have property appreciation increasing in our market 20 to 30% year over year for the last couple of years, obviously dependent on zip code, et cetera, but that's an average. We have rents increasing at roughly 18 to 20% year over year, depending on zip code, property type, et cetera. And so even though interest rates have gone up, yes, they have, the rents have gone up as well. So, there's kind of that sweet spot. Obviously, HOA fees impact that overall expense, and properties that don't have HOAs or lower HOAs, they're cash flowing a little bit more, but we're still seeing a huge interest in just investment property purchases here with financing. So.
Yeah, that's interesting. I mean, I still feel like Arizona is really the place to be, or one of the places to be, even with interest rates going. I mean, stuff in my neighborhood is flying off the shelf. It's would I pay the same amount for my house that it could go for now? Probably not. But and so that amazes me. But yeah, I don't see too many people losing losing money in short-term rentals right now, even with the interest rates that have crept up a little bit. I think that they can make it up. I think there's such strong demand here in Arizona. I mean, we get calls all the time from people coming from out of state wanting to know, hey, can you help us with buying something there or whatever it is? And it's the demand is stronger than ever. So I think we're in a good position here in Arizona for many, many reasons.
Yeah, and I think too, when we think about this, appreciation rate, I'm often asked, is there a bubble? Is it looming? Is it out there? I think we really have to look at the facts and not just be emotional and think, oh my gosh, it's what it was in 2008. It's a completely different market. There's so many different factors that are driving today's market that differ from before. So, population growth first of all, right? 34% of our buyer market are the millennial buyers. They're now in the buying market. That was not the case in 2008 to 10. The amount of jobs that are created here that are different types of industries that are being brought here, that's significant. So many people relocating. And I think also credit, just from a lending standpoint, it's so different today than what it was back in 2003, 4, 5, 6, leading up to 2008. So those are just some of the reasons that we are definitely not anticipating a real estate bubble. What I do think is appreciation will slow. Of course it will. Real estate is a market cycle. Just like any other business, it is a market cycle. So we will see appreciation slow, but that's not a bad thing. I mean, we can't keep up at a 20 to 30% appreciation rate. My goodness.
Well, and what's your solution to get more houses on the market too? I mean, that seems to be part of the frustration for a lot of people as well. I mean, I don't think there's any magic bullet, but that one seems to be the interesting part here.
Well, new builds, right? I mean, they essentially stopped building back in the 2008 to 10 timeframe, which now we're feeling the effect of that lack of building. So having builders build, that's going to be helpful. Also, I think just having people talk with a really experienced, educated real estate professional to really understand, like, what's your goal? Is it to move up? Is it to move down? And then talking, if you have to use a loan, then talking with an experienced mortgage lender that can really kind of break down what I think sometimes this fear of just the media and like rising rates, oh my gosh, the sky's falling. No, like historically, these are still decent rates. I mean, they really are good rates historically, if you start to look at it over the last 30 years. But we got to chunk down, here's how it would look. Here's your net proceeds. Here's the price of the current area that you want to buy in, and let's get the facts. I think that's what we have to do, as opposed to just reacting with all of this emotion and assumption. I think that's where the danger really is.
Yeah, I agree with you. I think there's a lot of fear in rising rates, but as you said, historically, they're still extremely low, extremely competitive. And so it's like, I'd take out a loan all day.
Yeah, yeah.
It makes more sense for me personally anyways. But yeah, I try not to buy into the media hysteria about the rising rates. It's a natural part of what happens. And if you look at it cyclically, it's just what happens.
Yeah, yeah. And if our country does go into a recession, which, the smart people out there are indicating that it's very likely that we'll see that, then generally interest rates fall historically during recessionary periods. So if you're buying today and you're still worked up about that interest rate, just know that there could be a potential for refinance downstream if in fact we go into a recession.
Oh, that makes perfect sense. So maybe you pay a little bit more now just because that's kind of what we're stuck with. And then, 6 months down the road, if it's determined that there's a recession, those rates may go down and it's an opportunity to refi. I got you.
Absolutely. Absolutely. Well, Patrick, this was such great information. I always enjoy talking with you. Thank you for taking your time. If people need to maybe pursue something with regard to this change through the Supreme Court and this law, how do they reach you, or what do they do?
I'm happy to send anybody who wants a copy of that opinion. I can send that to them if they want it. And they can reach me at patrick@mndglawgroup.com. That and is all the way spelled out. So MANDGlawgroup.com. Or my direct number is 602-533-2838. Happy to get my analysis to them on this new opinion. Happy to get a copy of the opinion so they can take a look at it themselves.
I so appreciate you. And just for anybody out there, if you do need a great attorney, especially with the focus on real estate, Patrick's the guy. I know I bug you all the time. Thank you for always answering my questions.
No, my pleasure. Thanks for doing these. These are fun.
You bet. We'll see you soon.